Okay, 6 o'clock. Welcome, everybody, to the Anacortes Planning Commission meeting for September 10th, 2025. And we have Mr. Hoagland here. Mr. Hoagland, would you please take the roll?
Mr. Mills?
Present.
Mr. McCombs?
Present.
Mr. Ryan?
Present.
Ms. Martin?
Here.
Mr. Stoneman?
Here.
Mr. Jarecki?
Present.
Mr. Courier?
Present.
Okay, would you please join me in the Pledge of Allegiance? Okay, item number 3 are the two minutes. The first one is for July 9th, 2025. Are there any changes? I do see a couple of typos, but we can just change the typos at a different time. Is there a motion to approve the minutes for July 9th?
So moved.
And a second?
I'll second.
Okay, motion by Mr. Mills, seconded by Mr. Jarecki to approve the minutes of July 9th, 2025. All those in favor signify by saying aye.
Aye.
Opposed? Minutes passed. August 13th, 2025. Any changes? If not, is there a motion?
I move to accept the minutes for the 13th as read.
Second.
Okay, moved by Mr. McCombs, seconded by Mr. Stoneman for the August 13th, 2025 minutes. All those in favor? Aye.
Aye.
Opposed? Those pass. All right, we are on to item number 4, public comment. So this is the time that any member of the public, either present or online, is welcome to come and speak to the Planning Commission. We would, about anything that's not on the agenda at this point, and we'll be happy to give you 3 minutes. We ask that you come to the podium and state your name and your city. And seeing no one from the audience, is there anyone online? No. Okay. Then item number 5 is public hearings, and this is a continuation of the public hearing from last time. And looks like Mr. Coleman is here.
Good evening, Planning Commission. My name is John Coleman, the Director of Planning, Community, and Economic Development. So at the August 27th Planning Commission meeting, we held a public hearing on the comprehensive plan document, and we had a lot of participation. We've elected to keep that public hearing open until September 24th. So what we're doing now is just this part of the agenda is leaving an opportunity for anybody that's come to speak to the comprehensive plan, because we published that it's going to be continued to be open. We don't have any further presentation or discussion items about the comp plan. This is just an opportunity for people to speak to the comp plan if anybody has any comments about that. And when we're done with that, we can keep the public hearing open and continue it. And then we'll do this again at the next Planning Commission until the September 24th one, when we'll have more public comment and potentially close it on that date. So that's all we have to say about this agenda item.
Thank you. So this is an opportunity for anybody in the audience, in person or online, to comment about the draft comprehensive plan. And this is part of our public hearing process. Is there anybody in the audience that would like to speak? Or anybody online? All right. With that, we will continue this public hearing until the next meeting. Now we're on to item number 6A, 2025 Comprehensive Plan Update, Development Regulation Amendments. This is a discussion item, and it looks like Ms. Grage is here.
Hi, good evening, everyone. I'm Libby Grage, Planning Manager, Planning Community and Economic Development Department. So I got to skip forward a couple of slides here. So yes. Development regulation amendments. I think I was just noticing I was slow to get up here because I noticed I put the wrong agenda item on the slide, so I apologize for that. Should be 6A, as you mentioned.
Details, details.
I hate when I do that. The purpose of my presentation to you this evening is to present and explain the proposed updates to the development regulations that are sort of occurring as part of the broader comprehensive plan periodic update process. And hope to just have a conversation and have the Planning Commission ask questions, identify items that need further discussion, more information, that sort of thing. So just keep that in mind as I'm going through. Feel free to stop me. And then just a little background and context. We are doing this overall comprehensive plan update because the Growth Management Act requires that we periodically review and update our tools that we use to plan for and manage growth. And those are our comprehensive plan and our development regulations, some of them. And so Anacortes is currently, as I mentioned, conducting the periodic review and update. And so that's why we are looking at the development regulations to make sure that they are consistent with state law and the rest and the comprehensive plan, and that they are implementing the comprehensive plan and state law requirements. Little more background about the relationship between the comprehensive plan and the development regulations. So they're two different documents, or they contain different information. The comprehensive plan is a statement of the community's vision that has goals and policies that direct and guide future growth in the city. The comp plan guides day-to-day decisions by elected officials and city staff. It has that future land use map that kind of shows the distribution of the planned growth throughout the urban growth area over the planning period, and we've talked about all of that before. The development regulations are different in that they are specific controls that are placed on development or land use activities. So there are laws about how a specific piece of property can be used and the requirements for development. So that includes zoning, site and building design requirements, parking, permitted uses, form and intensity standards, all of that good stuff. And then also the official zoning map is the visualization of the different zones, and each property has a zoning designation that is then corresponds with the development regulations, and that's how you kind of figure out what you can do on a piece of property. So I just wanted to give that background I know you all are familiar, but for those that might not be. So the City of Anacortes' development regulations are primarily contained in they are in the Anacortes Municipal Code, Title 19. Our Unified Development Code is sort of what the title or the section that houses that whole body of regulation for development. So that includes the permit review procedures. I already just kind of listed off this whole list. So But the permit review procedures, form and intensity, design standards, critical areas regulations, infrastructure requirements, all live in Title 19. So that's where we're focusing our work. This is showing how Title 19 Unified Development Code is organized. So there are divisions that are kind of broader categories of different regulations that apply to development, and each division has chapters, and then each chapter has sections and subsections, and keeps going and going. So the development regulation amendment types, so sort of the sources of the amendments that are being considered or proposed as part of this process, include those that are required by state law, so the Growth Management Act or other state laws require the city to review and revise regulations around certain topics. Like an example is accessory dwelling units. That's a mandatory item that the city has to address as part of this update. And then there are also the docketed amendments that are not mandatory, they're voluntary, but the city council docketed a pretty long list of amendments that it wanted to have considered as part of this comprehensive plan update process, included comp plan amendments and also development regulation amendments. And those are all, that was established by Resolution 3161 last year. So the mandatory development regulation amendments, this is just, I won't read through this, but it's a list, and this is also listed out in the staff report in your packet. So just giving an example of some of the items that we are required to address during this update based on new state legislation. And then this is showing the list of summarized docketed amendment proposals that we will be addressing as part of the update process. And one of those docketed items was the implementation of the Housing Action Plan recommendations and strategies, which the Planning Commission has been sort of discussing over the last year at various meetings. But there are many other ones. This is just a summary showing when the Planning Commission has sort of touched the development regulation amendments going back all the way to August of 2024. So, almost exactly a year ago, September 11th, 2024. So that is when we kind of began the discussion about the housing regulatory concepts, taking those housing action plan recommendations and translating them into changes in the development regulations. And Makers, our consultant that was working on that aspect of things, came and presented. Hopefully you all remember that. And then these are just the other dates where the commission has reviewed and discussed different code amendment proposals, almost all of them related to the Housing Action Plan and housing-related code amendments. So tonight is sort of a kickoff to the broader development regulation amendment proposal, which will include all of those amendments related to housing and the Housing Action Plan strategies, and then pulling into the mix all of the other required amendments under state law and the docketed items. Does that make sense? Okay. I know it's been sort of spread out over a long time, and so I just want, it's all coming together into one, hopefully one red line document that will contain all of the proposed amendments and then that will go out for public review and comment.
Ms. Gray?
Yeah.
I noticed in the packet it said it would come out for public review today. It will just be sometime before next week?
It will be tomorrow. Yeah, I had fully anticipated having that out today, and unfortunately, it did not happen. So I apologize for that. It will be coming out as soon as I can get it, and I'll send out an email to everyone to notify folks that it's available. So coming up, we do plan to have a special meeting at next week on September 17th. And that is because I don't think we'll be able to discuss all of the remaining amendments this evening. Staff is still working on recommendations for some of them. And so we hope to have all of that, completed and put together for the next meeting. And then we also have kind of a large update to our Division 5, Community Design is the title of that division. And you may recall our transportation consultant, Transpo, Chris Como, came in and talked with you all about the transportation element of the comprehensive plan when we were working on the transportation element a while ago. And so these are amendments to the street standards in the code. And so Transpo's been helping on drafting those to sort of implement the new active transportation. We have the new active transportation map and sort of clarifying what, identifying changes to street standards, and then what street improvements are required when new development happens. So he'll be coming on the 24th to give more information about that. So tonight, this is the staff report that was in your packet, and it contains basically the information that I just went over, but it also, at the end of it, includes tables that are organized by division in Title 19. So trying to sort of have an order to summarize all of the different proposed amendments. So just this example here, Division 1 is the general and legislative provisions, and there were only a few proposed amendments in that section, and the Planning Commission has already discussed those as part of a previous meeting. Does the way that document is laid out make sense to everyone if you've had a chance to look at it? I know it's a lot. Okay, good.
I do have a question, though.
Yeah.
So on the 17th, you're planning to bring back Division 5, but are we going to go through the other divisions tonight? Because I think, isn't there a Division 6? Yeah.
On the
And
7th, on the 24th is when Division 5 would come back.
Okay. And 6 and 7 is going to be tonight?
Division 6 and 7 is not going to be tonight. That will be on the 16th, or 17th, excuse me, next
Okay.
week.
As well as all the grade-in
Yes.
changes?
There
Okay.
are a few of the grade-in, the Planning Commission review items that we'll be able to discuss tonight. And then
Okay.
all of the rest that we aren't able to, we would discuss at the 17th. I would have staff recommendations for you in the packet that will be going out on Friday for those items.
Okay.
Oh, so this kind of summarizes how it looks like we'll have to sort of break down these remaining items. So tonight, we are prepared to go over the division. Division 2 is the procedures section, and one of the docketed items was to revise the permit review procedures. So we'll talk about that one. Co-living housing is another one that was a recommendation in the Housing Action Plan to address, but subsequent to that, there was some new state legislation that sort of changed things. So we've looked at that guidance and brought back a proposal for that to integrate co-living housing into our code, and then child care facilities as well. There was a amendment that was docketed from a property owner asking to allow for child care facilities, I think in the industrial zone, but also there was more recently legislation requiring the city to permit outright child care facilities in all zones except industrial, where it has to at least be a conditional use. But the city, I'm going to get to this, I'm going into too much detail, but that, we'll be talking about that. And then again on the 17th, all of the remaining items in Division 4 and 6, and then the 24th, Division 5, community design.
So just quickly before you get into it, there was some questions about whether we would have a quorum on the 24th. Okay.
I believe I'm the only one not here, but I wouldn't.
Oh.
I'm not here.
Okay, so only 2 will not be here, so we will have a quorum. So
That's great.
So we're good.
Thank you. Thank you for checking that. I know we wrote that down last time. Okay, so we'll see how this works, but I was just going to work from the staff report and attachment A to the staff report in your packet. Excuse me. So this is attachment A to the staff report in your packet, and I, on my version, highlighted the ones that staff is prepared to talk about this evening. And so the first one is the streamline permit review. So that was a docketed item. That number, that LEG 2024-17 is the number on the docket resolution. That's just how we're tracking each of those items. And so this amendment would affect, again, the procedures in Title 19, Chapter 1920-030, which is where you go to find out what type of permit various development types require. So the different permit types and decision types involved in the development process, and then also the associated procedures for review. So with this proposed amendment, the request or the initial proposal was to streamline review of shoreline permits, so shoreline substantial development permits, so that it wasn't such a, for some, you may recall, there's been some sort of simpler shoreline permits, like, a new dock, or, installing fiber in a trench, those types of permits. So trying to get those so that they're not going through the extended process that is involved in going to a public hearing, planning commission decision. And so the proposal is to change shoreline substantial development permits to a type 2 administrative decision. Well, should we go through the types of decisions, or are you all comfortable with where we're at in the code and what all of these review types mean? Would it be helpful to, I don't, yeah? Okay. Okay, so the table includes type 1, type 2, type 3 HE, which stands for hearing examiner, and type 3 PC, which stands for planning commission, and then type 4 city council decisions. So I'm going to zoom out a little bit. So, for example, if I wanted to do a short subdivision of my property, so to split my land into 3 lots, in order to determine what that process is that I would need to go through with the city, I'd come to this table. I would find preliminary short subdivisions, which is this one right here, and I would find out, okay, that's a type 2 administrative decision, which means that it's an application that is requires public notice, notice of application, public comment period, and then the director is the decision maker on the proposal type. So in the table, for example, the type 2, you can see these are the types of applications. So preliminary short subdivisions here, among the others. Whether a pre-app, and then the rest of the rows is talking about what the process is for processing the application. So is there a required pre-application conference? At the discretion of the director for these lower permit review types, and then for the higher level permit review types, it is pre-applications are mandatory. So that there are also requirements for neighborhood meetings for some types of applications. So, for example, type 1 ministerial action, which includes like a building permit, doesn't have a requirement for a pre-application meeting, because theoretically it should be a pretty simple permit application that you can review to the code and issue the permit. So continuing on, sorry, I'm bouncing around, but for the type 2 administrative decisions for a short subdivision as our example, the pre-application is at the discretion of the director. And in this draft, we are proposing to change the pre-application neighborhood meeting to, specifying the types of permit applications that may require a neighborhood meeting, to change it to at the discretion of the director. There is a requirement for a notice of application, so that means when the applicant has submitted a complete application. Yep.
Yeah, I do. If
Sorry.
you've seen, because we're going, neighborhood meetings, and I do find a little bit of a discord with that. If we've all read the influx of emails about our communities wanting to be informed, if anything, just informed. Do they have power? May not have power. Do they want to be informed? Do they want to partake in this? Yes, they do. And that's the voice of the people. I know it can hold up some of these decisions, and we're trying to streamline everything, but at the same time, we do need to listen to the voice of the people around us.
So for one example, the reason we're talking about making the pre-applications at discretion, So that's a pre-application or a neighborhood meeting. Those are different than the public comment period, which in these type 2, there still is public comment period, so
Yeah.
there'll be notice. The pre-application meeting, for example, when we had somebody requesting to have a dog grooming facility downtown.
Oh, yeah.
It strictly said, yes, you're required to have a neighborhood meeting. That did not feel like something that we should have required a neighborhood meeting for. So that is why we're giving discretion to the director for something minor like that. We don't want to put the applicant through the ringer of having a neighborhood meeting or a pre-application meeting, but we still have it, if it's a type 2, it still has public notice where people have the opportunity to comment.
Yeah, no, that's quite reasonable, especially when you're dealing with commercial. I think just whenever we have anything bordering, from what I'm getting feedback from, bordering residential areas and within residential areas, I think that's going to be the biggest concern of the people.
So you've described type 1. It sounds like type 2.
Yeah, I'm not, so, yes, so type 2, continuing on with our short plat example, there is a notice of application required. So once there's a complete application, a public notice is put in the paper, it's published in the paper, site is posted, notice is mailed to property owners within 300 feet, and there's a 14-day written comment period where whoever wants to can provide comments on the application. And for this for type 2, there's no recommendation because it's an administrative decision. So for these higher level review types, staff is typically making a recommendation to Planning Commission or City Council. So that's why that says no there for the type 2, because it's the administrator or the planning director that's making the decision. Pre-decision open record hearing is also not required for the type 2 permit review, nor is a closed record decision. Oh, way down here it says who the decision maker is, so type 2 is a director. And then continuing on down in the process, once a decision is made by the director, there is a requirement for us to issue a notice of decision to all of the parties of record. So anybody that commented on the application, and then also I think the site gets posted and the notice gets posted in the paper as well. So people that commented on the application will receive the notice so that they will know that the decision was issued and that the appeal period has begun.
And did I miss who hears the appeal?
So that's the next one. So the local, for type 2, for example, a local appeal is available to the hearing examiner for type 2 decisions. So if a party of record gets the decision, they disagree, they would submit an appeal in accordance with the requirement. There's requirements in the code that talk about, who has standing and what the requirements are to include in the appeal document, but they would file that with the city, and then that would be heard in an open record hearing before the hearing examiner. The hearing examiner would make the decision on the appeal.
You got a question?
All right. Yes, Mr. Ryan.
So if somebody does want to come in and appeal, because we've had this situation not too long ago where nobody knew what to do in the appeal process as far as application. I mean, there was about 30 days or so that went by before a roundabout way and an answer was done. So what is that appeal process if somebody does want to come in and do that?
I think I heard you ask what is the appeal process?
So what I'm asking is, what is that appeal process when we go into, if somebody comes into the planning department, or is there a place online where there is an application for the appeal? In a previous situation, that some of that information and knowledge was not known or available. And so just seeing if we do have that process available for public knowledge, and then those applications where those can be found.
Yeah, so the municipal code in, I don't have the full code here, but there is a section that is specifically about appeals, and it talks about how to file, who can file an appeal within what the time limit is to file an appeal, what information needs to be provided.
Does the planning department have a form available and readily available? Because that was another issue that came up on a previous
Yes,
instance.
there is a form.
And then who would we see on that one particularly?
Who would you see about getting the form?
Yes, just out of curiosity, just so that knowledge is out there.
It would be anybody in the department, planning staff.
Okay, thank you.
Okay. So we worked our way through the type 2 administrative decisions as an example, but the type 1 is ministerial. That means that there is no public, there's no public notice required. These are generally very simple, straightforward permit applications involving like a boundary line adjustment, building permits, clearing and grading permits, site plan review for smaller residential and commercial projects. And those are all director decisions. And then type 2, we just went through. Type 3, hearing examiner decisions. This goes through the full process and talks about the requirements for pre-application, neighborhood meeting. There is a requirement for a notice of application. There's a 21-day comment period instead of 14 days. And of course, the 30 days for shoreline permits, that's a state law, so we have to add that in there. And then in this case, for type 3, planning commission, hearing examiner decisions, the director is making a recommendation. The hearing examiner is holding the open record public hearing, and then also making the decision.
And appeals go to the city council?
Appeals, yes. Appeals of a hearing examiner decision go to city council, and city council holds a closed record appeal hearing, which means that only they're making a decision based on the record that was developed as part of the planning commission, hearing examiner public hearing process. So no new information basically can be added at that point. So type 3 planning commission decisions. So the planning commission has been hearing and making decisions on shoreline conditional use and variance permits, and also shoreline substantial development permits that are less than $1 million or less than 3 acres in size. And so this proposal would, as I mentioned, would move shoreline substantial development permits to a type 2 administrative decision, and the shoreline conditional use and variance permits to a type 3 hearing examiner decision. And that doesn't leave a lot left for the planning commission to do in a quasi-judicial role. And so I think the intent or the recommendation is to have the hearing examiner making more of those difficult or more controversial decisions where it's it's good to have, a land use attorney to make sure that they are looking at the decision criteria and issuing decision according to the approval criteria and the law. And this is a recommendation that we've seen before just in terms of risk management for the city, and also streamlining permit processes, making it more straightforward about what the overall process is. And well, that's all I have to say about that. Are there questions about that proposal?
I do.
Yep.
So I looked earlier too, and it looks like pretty much any quasi-judicial decision on the part of the Planning Commission is being recommended to be deleted. So not that I am against that, but I really would like to know, they just don't, whoever decided that or is recommending that, they just don't think that the Planning Commission is able to make quasi-judicial decisions?
I can address that. So it is no longer common for planning commissions to do quasi-judicial decisions.
And when you say in the plural, you mean
Like,
anywhere in the
I'm not familiar
state?
with any local cities that still use the planning commission to do quasi-judicial. This is something that risk management and city attorneys and land use attorneys just don't feel is a good practice, because planning commissioners are people in the community, and you might be sympathetic to your friends and neighbors, or you use a different set of criteria sometimes, and maybe could be emotionally moved for making decisions, whereas there's strict criteria in code and state law that needs to be followed to make sure that it goes through the proper process. So planning commissioners can get themselves in a lot of risk, and then the city at risk as well, if they're making decisions that are not following the criteria and the laws, which can very well happen when you're trying to be reasonable, perhaps, or if something seems right, or maybe you're just not familiar with all the criteria. So it's not a common practice for planning commissions to be making quasi-judicial decisions any longer. And so this is just something that has been a long time coming. It has nothing to do with the ability of anybody on the planning commission, but it's really to protect you and the city, because if a decision is made that is not based strictly on the criteria, the city can be held liable and be sued and lose significant amounts of money. There are certain cases where planning commissioners personally can be held responsible too. So, and this goes for city council as well, for quasi-judicial, and we're working on, working our way towards that possibly, if the city council is willing to.
Aren't you at the city council working your way to minimize the hearing examiner decisions because it's difficult to find them and to?
No, in fact, there was a state law proposed this year to require hearings examiners. That did not pass, but it's probably going to be coming back, and it's all for the same reasons that I just explained. Whereas, personal liability and risk liability for city council members also can come
Mr.
into play.
Dretsky?
If they're not available, if there aren't very many of them, what happens to the decision-making process if they're not available?
Well, there are, and the industry is catching up.
Okay. Catching up fast enough if this is implemented, that people will be able to get decisions in a timely manner?
Yeah.
I just have one other quick question. I didn't get a chance, and I meant to look at the RCW that guides planning commissions. Is and maybe you don't know, or maybe you know, are the quasi judicial functions of a planning commission still in the RCWs?
I don't know, but I would hope so because we've been doing it. But I don't think there's been any major changes to the RCWs. It's just not a common practice anymore to use the planning commission for quasi judicial.
Okay. Mr. Courier?
I just had a quick question on just the cross out of ADUs under type 1. I'm just curious about that.
Sure. So accessory dwelling units are permitted through a building permit. So we found that it was just a little bit confusing for people thinking that they needed two separate applications to apply for an accessory dwelling unit when it's a building permit, and then all of the reviews for the applicable criteria occur through that permit review process. So it's just trying to make things more straightforward and understandable for people.
Okay, we're on to, I think, type 4.
Yep. So type 4 decisions currently are decisions made by City Council, and those decisions include applications for a binding site plan, which is like a land division of commercial land or commercial or industrial land instead of residential. So 10 or more lots, and then also conditional use permits, and type 1 and 2, essential public facilities, framework development plans, preliminary subdivisions, and then the shoreline substantial development permits that are projects that are valued at more than $1 million or on sites more than 3 acres in size. And so again, the shoreline substantial development permits are proposed to be just not split out by what the valuation of the project is, because that's just a little subjective and difficult to, ascertain whether the information that's provided from an applicant is, correct or not. It's trying to figure out what the actual project value is difficult. And then also, preliminary long subdivisions are proposed to be moved to the hearing examiner as well. Well, are there any questions about that? And kind of the reasons are the same as what Mr. Coleman was just mentioning, trying to have the hearing examiner making more of these quasi-judicial decisions and leaving the planning commission and city council free you up to be looking at the bigger community policy issues.
One more quick question that comes to mind. With quite a few more decisions going to a hearing examiner, will that add to the cost for people that are building or appealing something?
That is something that we'll have to look at how the fees work if this particular proposal is ultimately adopted. But yes, it is, the city contracts with a hearing examiner, so it costs money for the city and for applicants. I think right now the fee schedule for projects that go to the hearing examiner has an applicant paying the cost of the hearing examiner, whatever that, and they bill in different ways. But I think our last hearing examiner, I shouldn't say, I can't remember. I think it was by the hour. So it just depends on how complicated or how long a case is going to take, how much the fee is typically.
Yeah, just just as a note, though, an unintended consequence when we are trying to make things easier for people to build and quicker for people to build, this process, it goes the opposite way as far as affordability. Just
If I can now offer a counter to that, one of the things that we hear is an obstacle to development is the unknown, and with the hearing examiner, it's a little bit more known process. You can schedule the hearing at any time, and I know for mom and pop type applications, yes, the money matters, but we often hear that, for larger projects, they're willing to pay a little bit more in order to move through the system faster, because time is money for a project like that. And, with the Planning Commission only having a public hearing, only having the opportunity every 2 weeks or month to get that meeting time, that can slow a project down, whereas the hearing examiner, we can schedule when things are ready.
okay.
All right, so I think that was what I wanted to cover for that particular item. So unless there are any other questions or comments, I will move along to the next one.
I do have a question. At the beginning, you have a little staff comment section. Yeah, right there.
Yep.
And you have something in parentheses, consider whether there should be a local appeal available for shoreline CUPs or shoreline variance decisions, etc. So
Yeah.
what are you thinking? And commissioners, what are you thinking?
Sure. So, so just to kind of explain how the current process works with shoreline permits specifically, shoreline substantial development permits, that where the Planning Commission makes a decision, there is a local appeal available currently to City Council. So that means that's a 14-day local appeal period. Shoreline permits and shoreline substantial development permits are required under the Shoreline Management Act to be filed with the Department of Ecology. After the local government makes its final decision on an application, once the decision is filed with Ecology, that kicks off a 21-day appeal period at the ecology level, where an appeal can be made to the Shoreline Hearings Board. So there's another appeal process available at that level of things. So by having a local appeal after the having a local appeal to the City Council after the Planning Commission makes a decision adds an additional 14 days before we can send the permit to Ecology to kick off the subsequent 21-day appeal. So there's, what is that? 21, 14, like a month. So you get a decision on your shoreline permit, and then you have to wait a month before any construction could begin, assuming that you got all your construction permits as well. So it's just it's a long, drawn out, it's a long process. It's a lot of waiting for multiple appeals. That doesn't seem necessary in a lot of instances. And so it's just a conversation item, like, is that something that makes sense for shoreline substantial development permits and then shoreline conditional uses and variances? Those types of permits actually require approval or a decision by ecology. So they're actually not just, taking in the application and starting the appeal period. They're reviewing it and then issuing a decision. So there's just multiple layers of review and appeals. So it's seemed like something that, potentially could be streamlined.
Comments from the commissioners?
Yeah.
Mr. Ryan?
Yeah, I mean, it seems like, those time periods, I understand that, they seem long and drawn out, a whole 45 days or whatever it compiles to based on whatever those applications are, but isn't that just part of checks and balance and allowing other people to do their research, do their appeals as well versus shortening that timeline on any opposition? I mean, it's obviously if I want something done, I want zero opposition because I want to get my stuff done. But that's why, is that what we're trying to do? We're trying to, looking at shortening these windows so this way we can streamline it? And then what would the delta be, 10 days, 15 days? I mean, I'm kind of curious there.
I'm sorry, can you get a little closer to the mic? Having a little problem hearing you.
So what I was going on about was, are we trying to remove and shorten those days? Obviously, the idea is, it sounds like we're always going to streamline, but isn't those time periods part of the checks and balance system, allowing somebody either who gets notified, them to get caught up, them to find the information, and so this way they have a reasonable amount of time to respond? Or is it just because we're holding up progress, and if we can shorten those windows, it's more likely that we won't have any resistance and we can push things through without outside influence? I'm looking at the checks and balance system and why there are those periods, why were they set there in the first place, and understanding that sometimes a week is really not a lot if you're on some of these when you're going like, hold on, I have an issue with it, and here's going to be the legal side, I got to contact this person. If somebody does find something with it, they have a process just so they can file that appeal by getting their legal advice or so on, and a shorter window may not allow somebody to have that voice. And I understand we want progress, but at the same time, are we taking into account checks and balance? Why were those timelines originally established?
So I think there's a misunderstanding of what's happening. We're not shortening any appeal periods. So I think just that takes care of everything that you were just concerned about. We are talking about potentially eliminating one of the local appeals for shoreline permits, because there is also a required appeal period at the Shorelines Hearings Board that has to also be offered. So we have a local option to have an appeal or not have an appeal. Right now we do. We could consider getting rid of our local appeal, because there still is an appeal process that is required and will always be offered at the state level. So it's a little bit duplicative to have an appeal period locally at the city and then an appeal period at the Shorelines Hearings Board. And it's actually caused confusion with applicants in the past too, when we had the appeal of a shoreline substantial development permit. They went to the Shorelines Hearings Board, but we were like, whoa, you got to come to us to appeal first, because that's a different way of doing it. Not every jurisdiction does the local as well. So we're just kicking that idea around to see if, since there always is going to be an appeal for shoreline permits at the Shorelines Hearings Board, do we consider getting rid of our local appeal for those? It's a topic of conversation. I don't even know that we made a recommendation on that one.
No, it was just a comment, staff comment in parentheses. So something that noticed as processing these applications, something that's come up, but we're not proposing to change the appeal periods for any of the other types of applications.
Okay, so just on the local level.
Local appeals for shoreline substantial development permits or shoreline conditional use or variance permits.
Mr. Mills has a question.
Yeah, please just help me understand, if an applicant is denied by the hearing examiner, the two state-level appeal processes, does the city or the
There's just
pub-
one.
It says here, they go to ecology for approval after the city's decision, then there's a 20-day ecology appeal period, and appeals going to the Shoreline Hearings Board. That
Yeah,
sounds like,
so one appeal. You said two appeals. There's just one appeal at the state level. There's the state review period and then the state appeal period.
are the Shoreline Hearings Board and the Department of Ecology two different appeals?
Well, it's only one appeal.
Well, who are they appealing to, the Ecology Department or the Shoreline?
Okay, it is very confusing. So Libby's gonna try to back us up, because, I was trying to make a
Well,
point,
even-
but
let
I
me-
think we need to back up a little, because it is a very confusing process.
Actually, my question was going to be whether it's one or two. Does the city or the public have an opportunity to be a friend of the court, if you will, and provide comment during that appeal process, or is that totally out of the city and the public's hands and at the state level?
Well, I think the city would be defending its decision at the Shoreline Hearings Board.
Defending the position of the hearing examiner?
That's a good question. I believe so.
I have not experienced an appeal at the Shoreline Hearings Board level. I can say in other situations, when a city decision is appealed for a land use action, it goes to the LUPA process, the Land Use Petition Act process. And then the city defends our decision, and our city attorney becomes involved. And so that's why we're a little bit, we would go to, if somebody appealed something, one of our decisions to the Shoreline Hearings Board, we would immediately contact our city attorney and say, okay, now what? So we're not real well-versed in what the actual process would be if it goes to the Shoreline Hearings Board. What we're trying to point out is there's, right now, for shoreline permits, there's two different appeal periods, which is a little odd, but not illegal apparently. So that's the way we've been doing it. We do have that option. And so we're just considering, do we eliminate our local one since there's still the state appeal one?
And I guess where I'm at is I'm okay with eliminating the local one as long as the local can participate at the state level in the appeal.
Look, I think in order to appeal at the local level, a party needs to have standing, which is defined in our municipal code. So, and I don't remember the definition off the top of my head, but I think it's somebody that has participated in by providing public comments during the public comment period, or if there's a public hearing at the public hearing, and provided their name and full address, then they become a party of record. And only then are they, other than the applicant can always appeal, but people that aren't involved in the application, you have to be a party of record to make an appeal at the local level. So you would have already had to have participated in the process. You couldn't come in after the decision was issued, I don't believe. Okay.
Okay.
That was a fun one.
I think we beat this one to death.
All right, well, thank you for that discussion. We'll move on. So there are only two others that staff was prepared to go through. Concurrency, not that one. So co-living. This was, as I mentioned, there was a recommendation in the Housing Action Plan from several years ago that called kind of this type of living arrangement, I think it was single room occupancy or something was the terminology that was used in the HAP, in the Housing Action Plan, but that was prior to this new state law that was adopted in 2024 that basically requires cities to allow co-housing living wherever multifamily with 6 or more units are allowed by right currently. And so let me try and find the definition of co-living so we can all know what we're talking about before we go through where it's permitted.
Could you zoom that up a little bit?
Oh, zoom in? Yeah. Is that all right? Okay, so co-living, a lot of the regulations for co-living and what the city is and isn't allowed to regulate is dictated by the state law. So the definition for co-living housing is a residential development with sleeping units that are independently rented and lockable and provide living and sleeping space, and residents share kitchen facilities with other sleeping units in the building. And then the definition doesn't preclude an option for sleeping units with bathrooms or kitchenettes. So it's just another type of living arrangement where, multiple lockable rooms are rented to individuals or households where they are sharing common space, common kitchen area. So it's another option that, I think, there used to be a lot of that type of housing years and years ago. And this is just kind of recognizing that and bringing, saying to cities, you gotta allow for this type of living arrangement in your code. So in Anacortes, these zones where co-living housing is, sorry for zooming around here. So in residential zones, which includes R1, R2, all of the R zones up to Old Town, which is OT. The R4 and R4A zones are where multifamily housing is permitted. So multifamily 6+ units is allowed outright in R4 and R4A, and therefore co-living or co-housing living must be permitted under the state law. So we've just changed the permitted use table here to add this new housing type, and then the P under R4 and R4A to indicate that it's permitted outright. This reference over in this column is referencing the special use standards, which I'll go back down to here in just a minute, but those are the specific regulations that are applicable to that housing type. So, but first we'll take a look at where co-living housing would be permitted or is proposed to be permitted in Anacortes' mixed use and industrial zones. And so again, wherever multifamily is currently permitted outright, we must allow co-living housing as well. And so in the central business district, commercial, marine mixed use, and commercial marine zones, multifamily is permitted. So we're proposing to allow outright co-living housing in those zones. And then this manufacturing and shipping zone permitted notation here is really a carve out for an area where multifamily is currently permitted, south of 2nd Street, west of Commercial Avenue, north of 3rd. So it's basically the Olson
Yeah.
building, the Olson property. So that's just making the, since multifamily is allowed there, then we would say that co-living housing is also permitted.
Quick question. So I know that we're considering changing that Olson Buildings zoning if, and I think that would be the only thing that applies in the MS zone. So would this table change if, yes?
Yes.
That's,
Yeah.
okay.
Yep. Good point. Okay. Might have put that somewhere, but I don't remember where. So I'm going to zoom down to those use standards in 1943-160. So this is where that table directs you to find more information about, definition of co-living housing and what specific standards are. And so we have the definition. We have definition for sleeping unit, which is proposed to be the same as is defined in the adopted state building code. And then there are also proposed standards for room dimensions, which is basically also just referencing compliance with the state building code as well. And then design standards would be applicable to this type of housing. And for purposes of applying design standards, we would look at this type of use as a multifamily development. So any site or building design standards that are applicable in the code would also apply to co-living housing. There is, and also I think there's a special, something in the state law that says that you can't require more than a certain ratio of parking spaces per unit as well. And so that would be an additional change that we will talk about in Division 6 when we come back with that information, but you'll see that there. And then the zone-specific standards is just related to that one location in the MS zone. So this would go away if that land use amendment were approved. Are there any questions or discussion about co-living housing? Okay.
Keep going.
All right, I think I only have, no. I'm sorry for bouncing around. So we could also talk about this one is regarding childcare facilities. So there, as I mentioned, there was a request from a property owner that was docketed on as part of the periodic update amendments to allow daycares to be permitted in the industrial zone. Subsequent to that, so really more recently, SB 5509, which was adopted, I guess I didn't put that, but it was pretty recently, requires that we allow childcare facilities to be an outright permitted use in all zones except industrial zones or light industrial zones. But in those areas, the city does need to provide for at least a conditional use approval of an on-site childcare facility, except in or around high hazard facilities. And the adoption deadline for that particular required change to the code isn't until 2027, but since we'll have to do it anyways, and this was a topic that was brought up in the docketed items, we figured we could look at making that change with this update process. And so that's kind of a question for the Planning Commission is, should the city allow for childcare facilities to be just permitted outright in all zones, including industrial and heavy manufacturing, or should there be, development standards that are associated that maybe, say that it has to be an on-site facility and only in certain, areas, supporting a employment, location. So that's a question for the Planning Commission, what you think about that.
Okay, Mr. Ryan, you're close enough. His finger is close.
Right. I'll try to speak into the mic.
So, thank you.
Yeah, so no, I don't have, I think it's necessary, obviously. The industrial working class individual needs childcare. They need accessibility, they need it close. I think, the big thing is safety for the children at the same time. So obviously, you can't be in the middle of the shipyard, right? But how close, what is that distance, and would it be, overhead hazards and decibel ratings, I think would be my largest concern.
Anybody else want to weigh in?
I would concur with the idea that it's necessary, and again, just the right regulations associated with it, but in terms of just being allowed to be in a zone, I would concur with that.
Okay. So 2 people are speaking in favor of having it being permitted outright. Mr. Courier?
I would also agree with that, permitting it outright.
Mr. Mills?
I think I'm in favor of permitting outright, but I do want to ask, when it comes to issues of safety of the children, would design standards address things like separation from traffic and that sort of thing?
So the city is allowed to apply reasonable standards related to like pickup and drop off locations. But as far as, any hazards that might be associated with, hazardous uses or, really heavy manufacturing uses, I would need to do more research into that.
I think what pops into my mind is the grade school on 12th has, waist-high fencing, which keeps
Yes.
the outdoor area of a daycare facility, keeps the children separate from traffic.
And I think that there are requirements, licensing requirements, so that would require certain height fencing, so it might not need to be in our code.
Yeah, good
Yeah.
point, yeah.
Yeah, the state has a separate criteria for childcare centers, the fencing. I think they might even have like pickup area requirements, and it can get fairly detailed.
Staff clarification, I'm now for permitting.
Okay, I'm going to speak up in favor of conditional use for this one, just because we're talking about children, and it's just a precaution, but we're talking about children in an industrial zone. Might be perfectly fine. Yes, we need childcare, but I would definitely say this one needs a conditional use, my opinion. Mr. Dretsky.
I agree with Dr. Martin on that, absolutely.
I guess I have a question. What distinguishes, I understand the difference between industrial and heavy manufacturing, but you could have the same hazards in light manufacturing as well, right? So I think you mitigate that with having the right standards in place in the first place, right?
I think there's a difference between light industrial and industrial, but
There is, but as long as you have those standards, I mean, you need to build to the same standard regardless of what zone it's in, right? So how does, I don't understand what the,
There could be hazardous waste, there could be all kinds of
I think, but
things.
you could see that in any of those zones. You could see that in light manufacturing, and it's already permitted by right there. You could see it
Possibly.
in, so is there something, it seems like an emotional response to go to a conditional, because we hear the words heavy or industrial, but how do we make sure that in light manufacturing areas, we're protecting children that are in daycare there as well? So we're doing that by standards we set, right? Is there some different set of standards that we need to use in different areas?
So there aren't, I don't know off the top of my head the specific use standards, because I didn't include it in this. But I can bring that information back and say, here's, what the specific use standards are for childcare facilities in different zones that the city has adopted. And then we could also provide information about the state, licensing requirements, because I know that they have, like, the fencing, they may have standards that might, mitigate the concerns about, nearby hazardous facilities. I don't know that. I would need to get more information on that, but I can bring that back.
I think it's worth looking at. I have the same response my initial response is the same, like, absolutely, this should be conditional. But I don't know, I guess I think we want to have safe places for childcare in any zone. So how do we?
What are those standards?
How do we do that? What standards are required? And is there something specific about those two zones that require us to do something different?
Well, in those two zones, wouldn't as well we go, fine, these are permissible, here are the standards within these guidelines, and these restrictions might be a little bit more heavier in those areas, but still permissible under guidelines.
Go ahead, Mr. Dretsky.
It seems like it wasn't all that long ago that the port was here worried about infringing on their zoning, about what was going to be allowed in there, which would impact and negate some of their uses, what the uses they wanted to see on that property. So how does this fit in there? I mean, I guess I can make an argument that there's several zones that should be conditional use, including not just industrial.
Okay, so this is a bring it back.
Great. Will do. I'm sorry. Anything else on that one?
I don't think so.
Okay. I think that's probably where we stop. There's still work to do on the rest of these, and I will bring back the information you've requested, and then recommendations on the rest of these at the next meeting.
Okay, one more question.
From me.
Okay.
Going back to parking on the co-housing, the standards are going to be like multifamily, so would they be the same standard as studio apartments?
I believe that it's different than studio apartments because I think that there's actually, I think it said co-living housing is considered multifamily for purposes of applying the design standards except for parking. So I think there's a special parking requirement just for
I don't think
co-living.
that's what I read there.
Oh,
okay. I think it said parking should be the same as multifamily, unless I misread it.
In one of the zones, yeah, that you did see that. That was specifically in the MS zone.
Oh,
And that would be off-street parking?
I think we're talking about the Olson building again.
No, I'm not talking about the Olson building. I'm talking about somebody who wanted to put something new in. I'm not sure why, but I'm sure
So-
economically how viable that would be, but
are we talking, So design standards for the purpose of meeting the project design standards in Division 6, except for parking.
Ah, okay.
This use is considered a multifamily use when interpreting applicability provisions.
I don't think I agree with that. There's a comma after 19.64, and doesn't that change the thought?
Sorry, 1964?
Yeah, where you just were. Yeah, right there, design standards.
I'm sorry, still not following where we're looking
Yeah,
here.
you're pointing
This-
right at it.
this?
So, yeah, where it says, except for AMC Chapter 19.64, comma, parking, this is to be considered a multifamily use when interpreting applicability provisions.
So does that mean the parking requirement is the same as multifamily?
No. That's not what it's intended to read, so if we need
Okay.
to make clarification there, then we
Yeah,
can do
I
that.
think we do, because I'm not sure it's clear.
Yeah.
And
So-
Maybe we rewrite that just to be
Yeah.
a little clear.
But the intent is to include in the parking section, which I'm really sorry I don't have.
That's
but
okay, we'll get
is-
there.
Yeah, is to include a category specifically for co-living housing type. And here's
Okay.
the specific parking requirement for that use.
Okay, so let's just clarify, since we've gone through what we can go through tonight. So next week, are we going to go division by division? And look-
I'm happy to do it however the commission would like to do it. That's the way that my brain was organizing it, but
yeah,
if there's a better way.
no, I think
Okay.
that's good, just understanding that we're going to look at the different divisions and recommendations within that.
Yep. So going back to just to clarify, going back to the staff report and the tables for the
Right.
different divisions, we talked about in Division 2, we talked about these ones. So I would just start at the next meeting with, sorry, I've got a rogue hair. Just work our way down the list on these for each division. Okay. Yep. Do that.
Is that okay with everybody? Yeah.
Oh, shoot. I just realized I had one more slide here, which I think we sort of already talked about, but the next steps for the Planning Commission schedule and looking at the comp plan update and development regulations. So a special meeting next Wednesday. I'll be sending out the packet on Friday and a special meeting notice as well. So expect to see that then. And then September 24th, again, we'll have Transpo coming to talk about the street improvement, the new amendments to street improvement requirements in the code. And also the continued public hearing for the comprehensive plan and potentially deliberations and recommendations on the 24th, if that works out. And then we have potential special meeting on October 1st to continue deliberations on the comp plan if needed. So that would also be a special meeting. And I think we've talked about all of these prior, but it's looking more likely that we'll probably be needing these special meetings. October 8th is a regular meeting. I don't think either John or I will be here, but there might be a shoreline substantial development permit that could be coming to you. That's still to be determined. So we'll update you on whether we'll be having that meeting. And then the plan is to have a public hearing on the development regulation amendments on October 22nd. and potentially deliberations and a recommendation. If not, we're looking at either a special meeting the next night on a Thursday or the next Wednesday, which would be the 29th. So we can kind of finalize those dates as we get closer, but just so everyone's aware that that's sort of what we're thinking right now.
Quick question about the comprehensive plan. You know, we've gone in depth in line by line in section 1, but section 2 has been referred to, parts of it have been referred to, and we have definitely used that as the basis for a lot of section 1. But I think there's quite a bit in section 2 that as a commission we haven't looked at, other than it's been in our packet a few meetings ago. Is that it? Are we good with that? Are we going to actually talk about anything in that section of the comprehensive plan?
If the commission would like for us to go through, we can certainly do that. Are there specific sections that you would be more interested in going through line by line, or just kind of an overview? I'm just for myself thinking there's a lot of reading in that second section that I haven't seen before, that is new, that I need to read carefully, so I don't know. But if we're adopting the whole thing and we haven't even talked about most of section 2, yeah. I don't know how that fits in, or how much time, I really don't know how much time that might take. Yeah, I mean, I think we can certainly do that. It would be, because it is, like you said, it is a lot of information, and a lot of it is, just updating background information. It doesn't contain.
There's a lot that really like the housing allocations is in that section. We've talked about that. We've seen those documents. There's quite a bit that we have seen. But sorting through, and you've talked about this is new, this is new, this is new. So, I mean, we've been on notice that there's some new things in there, but there's quite a bit of new things that, as a commission, we haven't ever looked at together.
So the idea behind book 2 is that that's mostly background information. So it's just updating, how many of each thing that the city has now, for inventories, and that's not where the policies and goals are. The policies and goals are the things that we went over very carefully. Right. That part isn't the one that's setting any policies. So it was less, we were less concerned about going over that line by line. While there's a lot of updated information, I don't know that I can't think of anything offhand that is changing a policy direction or anything that would be anything besides
when we
factual.
when we adopt the comprehensive plan, we adopt part 1 and part 2.
Yes,
correct?
absolutely. But our plan was not to go over it individually line by line, because a lot of it is not something that is going to be necessarily controversial. If there's things in there that you have questions about, data that you have questions about, maybe it's best for you to, is it too much to ask for the Planning Commission to then say, oh, I have questions about these specific things when going through it? Or do you want to go a different tack?
I think Libby has given us, when we had the 600 and some page document, you did say to us, this is new, this is new, this is new. And I know I made note, okay, this is new, I need to look at that. But I know we haven't discussed or looked at any of those items. And I understand background information and not the need for line by line. But if we're adopting the whole document and we haven't discussed, or just saying this is a new part in here. I don't know, it seems like we should probably bring that forward. Mr. Mills?
Yeah, I'm not in favor of line by line.
No.
But I would like the opportunity, as we've done on other parts of the plan review, where the chair walks us through, in this section, are there any questions? And often there are no questions, but it gives us
Right.
the opportunity to ask any clarifying questions. There is parts that are going to be new. I think this is the section where the glossary of terms is going to be inserted,
Yes.
and so that will be brand new
Right.
to us. And I noted we had quite extensive public comments in our packet this time, and there was a lot of comments in there about concern about terms and consistent use of terms. So I think that review is going to be important, at least the opportunity to ask questions, but not line by line, please.
Well, I mean, I think we could plan to do that potentially at the 17th or the 24th. I could just bring back I think in the staff report for the public hearing on the comp plan, whatever that date was, there was a kind of a summary that said, for each section, here's the new kind of elements or the changes to the background information, really, really super high level summary.
Right.
But we could just, like you said, not go through page by page, but just, I don't know how we would do that. We could just go through that document that has kind of the summary
Yeah,
of things.
that would be fine.
Okay.
And I agree. I don't want to do line by line for that, but I think it would be useful for us to at least have the opportunity to
Yeah.
make sure that we're reading it. If it's going to be adopted, it would be good that we've read it.
Yeah.
Chairman?
Yes.
And for myself, I don't need a presentation
No.
of that section. Just as a commission, if we walk through it and have the opportunity to ask staff any questions to make sure we understand, that satisfies my need.
Okay, I see heads nodding about that as well.
If there are things that, as you're reading it ahead of time, that you have questions about, please feel free to send me an email or ask, and then I can be better prepared to provide that information at the meeting.
Sure.
So I think 17th is next week. So maybe prior to the 17th or the 17th, if you were able to get me that information, that way I could, when the packet goes out for the meeting on the 24th, that'll be the week before, so that's 2 weeks
Why don't
away.
let's just use the document that you've already done, so you're not creating another document, because you did have, here's a few sections that have new information, and
Yep.
let's just use that as the organizer, and we
Okay.
can go quickly through that.
Okay. And give me a heads up if there's
Yeah.
anything you think of beforehand.
Yes.
Appreciate that. Thank you.
Sure.
Okay. That's all I have
Okay,
for this item.
thank you very much.
Thank you.
Okay, we are on to item 7, Planning Department update.
Good evening again, Planning Commission. So, the Planning Commission hasn't passed anything, made any recommendations on anything that have gone to City Council, so there's no follow-up on anything like that. So, as far as I know, there's no new information since 2 weeks ago. Sorry.
That's okay. We do have 2 commissioners that attended a presentation by North Star last night. And so, Mr. Mills, put you on the spot. anything you want to say about that meeting?
I'm a big fan of the keynote speaker, and the gentleman is a recovering investment banker who decided that he wanted to become involved in housing and the study of housing and the causes of homelessness, and has approached it and written a book in a quite academic manner. He first spoke at the North Star all-day seminar out at the casino back in was that July. And I thought, and perhaps it was having the benefit of having heard his presentation or a similar presentation a couple months ago, last night's presentation was more enlightening, whether it was he changed his presentation or I got smarter because of having heard it the first time. But I think his book, and I'm trying to remember the name of it now, shame on me.
The name of the book is Homelessness is a Housing Problem by Greg Colburn.
Yes, that sounds right. After his first meeting, I actually exchanged emails with him, kicking back and forth some ideas, and found him delightful to communicate back and forth with. I have to admit I've yet to read his book, but I did make notes, and I'm dedicated to doing that. I do recommend these North Star seminars. They're very useful, even if you don't agree with everything you're hearing. It opens up your mind, and so I find them very beneficial.
And I would also concur. It was an interesting meeting. There were, I think, about 200 participants. And the professor, he's a University of Washington professor, who gave a lot of interesting correlational data. So looking for the correlation between homelessness and I was interested in things like weather. Is there a correlation between, the kind of climate and the amount of homelessness? Is there a correlation? Obviously, there's a correlation between poverty and homelessness, but he was looking at a lot of correlational data. What I thought was interesting is that his conclusion was a causation conclusion, that homelessness is, the housing needs is the cause of homelessness. So he used correlational data and then kind of switched it to a causation. And I thought that was interesting. But as Mr. Mills says, definitely opened up your perspective about a lot of things. And it is something that we talk about all the time. So there's our update.
Thank you.
Anything else for the good of the order? With that, we are adjourned, 7:42.